Report of the Central State Relations Inquiry Committee, 1971, Government of Tamil Nadu, read by Ramani. Chapter 8, The Governor, discussing the question whether the office of governor need be retained. Thiru Ashok Chanda, in an article contributed to the Illustrated Weekly of India, March 15, 1970, says, quote, when the Congress came to power at the center, as also in all the states, the chief ministers were held to be repository of real power, and the governors regarded merely as puppets to perform at their manipulation. But with the Congress debacle and the growing instability in all the states, the situation has changed and the governors have become functional. Circumstances have made it possible for them to take a hand even in ministry making, and even those who disputed the discretionary powers of the governors are now reconciled to the view that they have a positive role to play in ensuring the stability and progress of their states. The need for the office also arises when the president takes over the administration of a state. In the new situation, the office of the governor should not only be retained, but his authority should be clearly spelt out. It's a hopeful sign that the governors are no longer inclined to consider themselves instruments of the center under compulsion to act on its direction or in its political interests. The governor is the head of the state. He is appointed by the president, that's to say, the central government, and can be removed by them. The following points arise for consideration in relation to the office of governor. 1. How far should the state cabinet be associated in the matter of appointment of the governor? 2. The relationship that should subsist between the governor and the central government. 3. The relationship that should subsist between the governor and the state cabinet. 4. Whether the Constitution provides for the exercise of any power by the governor in his discretion, that is, whether the governor could exercise any of his functions without consulting the ministry or contrary to the advice tendered by the ministry. 2. Point 1 above, the Constitution merely states that the governor shall be appointed by and hold office during the pleasure of the President. It does not provide for consultation with the state government. But at the time of framing the Constitution, one of the members of the drafting committee, Sir Alladi Krishnasamy Iyer, expressed the hope that a convention would grow whereby the Government of India would consult the state government in the selection of the governor, although there is no express provision which requires such consultation. The present practice is to consult the Chief Minister before the selection of a governor is finalized. The provision relating to the appointment of the governor underwent several changes before it became part of the Constitution. The study team, appointed by the Administrative Reforms Commission to consider the center state relationships, has stated that the present practice of consulting the Chief Minister before the selection of a governor is finalized should continue. It has, however, added that this should not dilute the primary responsibility of the center to appoint a competent and suitable person. It's difficult to understand the statement of the study team as to the dilution of the primary responsibility of the center in this regard. In the ordinary course of events and under normal conditions, the governor has to function as a constitutional head, which means that he has to abide by the advice tendered to him by the cabinet. In the interest of securing harmonious relationship between the head of the state and the state cabinet, it is but proper and desirable that the state cabinet should always be consulted. In the alternative, it may be provided in the Constitution itself that he should be appointed by the President in consultation with a high power body composed of eminent jurists, lawyers, and administrators. Sir B. N. Rao, constitutional advisor, in his memorandum of May-June 1947, suggested the setting up of a somewhat similar body to advise the President court in such matters as appointment of judges, unquote. Thiru K. Santhanam and Dr. K. Subbarao also have suggested that the governor should be appointed by the president in consultation with some high power body. Point 2 above, by virtue of the powers of appointment and removal vested in the central government, it may be stated that the governor is virtually a subordinate of the central government. This position of subordination and the possibility of the central government granting him extension of the term of office or some other suitable assignment may be said to affect the individual judgment or discretion of the governor in the discharge of his functions as the head of the state. Though the provisions of the Constitution to some extent appear to make him an agent of the central government, it is desirable to lay down guidelines as to the matters in respect of which he should consult the central government or in relation to which the central government could issue directions to him. Points 3 and 4 above, these 2 points are interrelated and may be considered together. The relationship between the ministry and the governor depends on the answer to the question whether, under the Constitution, expressly or by necessary intendment, any discretion is vested in the governor. The discretionary powers, so called, were introduced for the first time in the Government of India Act 1935, just prior to the inauguration of the provincial autonomy on the 1st of April 1937. The governor acted with two different sets of advisers, namely, 1. A popular ministry to advise him in relation to what were then known as, quote, transferred subject, unquote, and 2. The Executive Council to advise him in relation to, quote, reserved subjects, unquote. The 1935 Act demarcated the functions of the governor into three different categories. They were 1. Functions to be exercised by the governor in his discretion, 2. Those to be exercised in his individual judgment, and 3. Those to be exercised by him on the advice of his cabinet. The instrument of instructions issued to the governor made it clear that in relation to those functions which he had to exercise in his discretion, he need not be guided by the advice of the ministry. In relation to functions to be exercised by him in his individual judgment, he had to consult the ministry, but he could overrule the advice tendered to him. It was only in respect of the residuary matters that the governor was obliged to act in accordance with the ministerial advice. There were various provisions in the draft constitution which expressly required the governor to exercise his discretion in relation to the matters specified in them. The special committee which considered the draft constitution in April 1948 suggested that since the governor was to be nominated by the president, all references to the exercise of functions by the governor in his discretion should be omitted. During the consideration of the draft constitution as modified by the special committee, Dr. Ambedkar made it clear that the governor would not exercise any functions in his discretion and that according to the proposed constitution he would be required to follow the advice of his ministry in all matters. The Constitution does not provide for the issue of any instructions to the governor, nor does it vest any discretionary powers in express terms on the governor, except in relation to certain specified matters. The study team of the Administrative Reforms Commission has, however, come to the conclusion that the governor can, in his discretion, withhold assent from bills under the functions endowed on the governor by statute. For example, chancellor of a university would fall within the area of discretion regarding the statement that the governor could exercise his discretion in relation to withholding of assent to bills passed by the state legislature. It has to be pointed out that the proviso to Article 175 of the draft Constitution, as it stood in February 1948, specifically required the governor to exercise his discretion in relation to the return of bills to the state legislature. As already stated, the special committee decided to omit all references to the exercise of the functions by the governor in his discretion. It's therefore difficult to understand as to how the study team has come to the conclusion that the governor has discretion in the matter of returning bills passed by the legislature. The provision in the draft constitution conferring discretionary powers in the matter of returning bills was eventually omitted. In the matter of returning bills to the legislature, as in other matters, the governor is bound by the advice of his cabinet as regards statutory functions referred to by the study team, such as chancellor of university. This view seems to be based on the decision of the Allahabad High Court in Jyoti Prasad versus Kalka Prasad, AIR 1962, ALL 128, when it was held that the governor is identified with the state government only when he exercises the executive power of the state and not when he exercises a statutory power. Commenting on the decision of the Allahabad High Court, Basu says, quote, in the present context, however, we are not concerned with the question of the status of the person appointed by the governor in exercise of his statutory powers, but the question as to the nature of the statutory function of the governor, say, the function to appoint an officer of the university or some other statutory corporation with respect to which the governor has been endowed with powers and functions. Are such functions to be exercised with ministerial advice under Article 163, and can these be delegated to ministers under Act 166, Clause 3? If it could be said that the legislature has conferred those powers upon the governor because of the confidence it has in his personal capacity, just as a settlor would have done when he appointed the governor a trustee in his personal capacity, it could be safely predicated that such a statutory business is not a business of the government of the state within the meaning of Article 166.3. But such a view, it submitted, cannot be taken because the appointment of the governor under a statute relating to a university or other statutory corporation is not made in his personal capacity but ex officio. It continues only so long as he holds the office of governor. It would follow, therefore, that the governor is appointed to such statutory office by the legislature only because he is the head of the state government and only because such appointment cannot possibly be made in favor of the state government, because the state government cannot, in the nature of things, be appointed to hold an office. If this be correct, the statutory functions of the governor must be regarded as included within the business of the government of the state under Article 166.3 and within the meaning of functions in Article 163.1. Therefore, even in respect of statutory functions ex officio, the governor has to necessarily act on the advice of the cabinet. The question as to the discretionary functions of the governor was considered by the Supreme Court in Ram Javaya versus State of Punjab, AIR 1955, SC 549 at page 556. The Supreme Court held that the governors were constitutional heads of the executive and that real executive power was vested in the Council of Ministers. A similar view has been expressed by the Supreme Court in T.M. Kanyan versus ITO Pondicherry, AIR 1968, SC 637. Again, Granville Austin, in his book The Indian Constitution, Cornerstone of a Nation, has categorically stated that the governor occupies the same position as the English monarch and that the governor has to act in accordance with the advice of his cabinet in all matters. To place the matter beyond doubt, Article 163(1) may be modified by making it clear that the reference to discretion is only in relation to the matters in respect of which there are express provisions. For example, Assam. The study team of the Administrative Reforms Commission, which considered the center state relationships, has also referred to the discretion of the governor being exercised in relation to three other matters, namely 1. Appointment of Chief Minister, 2. Dismissal of ministry, and 3. Dissolution of legislature. The study team itself has indicated that the point is arguable. It must be mentioned here that in appointing the chief minister, the discretion of the governor is in large measure controlled by two provisions of the Constitution. One is the provision which states that the Council of Ministers is collectively responsible to the Assembly. This means that only a person who has the confidence of the legislature can be a minister. The other is that no person can be a minister for more than 6 consecutive months without being a member of the legislature. Normally speaking, the governor will have to call upon the leader of the majority party to form the ministry. So, also, in the case of dismissal of the ministry, the governor will have to find an alternative ministry. As regards the dissolution of the legislature, what Dr. Ambedkar stated in the Constituent Assembly in relation to the President will apply here. Dr. Ambedkar, after referring to the practice in England, concluded by saying that the President will have to ascertain the feelings of the House and that it must be left to the President to arrive at a correct decision. The principles which should be applied to the appointment of Chief Minister, dismissal of the ministry, and dissolution of the legislature cannot be different from those applicable to similar situations in England. The principles applicable to the situations mentioned above in England are well settled and they need not be restated here. What should be noted is that in discharging his functions, the governor should be under no pressure from any external authority. Thiru G.S. Pathak, Vice President of India and Chairman of the Rajya Sabha, in a speech inaugurating the National Convention on Union State Relations at New Delhi on the 3rd of April 1970, explained the position regarding the discretionary powers of the governor in the following words. Quote, he is the constitutional head of the state to which he is appointed, and in that capacity he is bound by the advice of the Council of Ministers of the state, except in the sphere where he is required by the Constitution, expressly or impliedly, to exercise his discretion. In the sphere in which he is bound by the advice of the Council of Ministers, for obvious reasons, he must be independent of the centre. There may be cases where the advice of the centre may clash with the advice of the State Council of Ministers. In the sphere in which he is required by the Constitution to exercise his discretion, it's obvious again that it is his discretion and not that of any other authority, and therefore his discretion cannot be controlled or interfered with by the center. Unquote. Foreign jurists have expressed similar views regarding the discretionary powers of the governor. Professor Alexandrovich, in his Constitutional Developments in India, explains the position thus: quote, the governor, Raj Pramukh, was clearly intended to be the nominal head of the state, and this is his position in practice. Except in marginal cases, his pleasure is accorded and withdrawn from the ministry automatically and not as a matter of discretion. Unquote, page 142. Caught in the closed world of local politics, he can hardly disregard the advice of his ministry. As to the appointment of his ministry, his action is determined by the policy of the majority party or of a viable coalition of parties in the legislature. Unquote, page 144. Again, Granville Austin describes the position of the governor as follows: quote, the discretionary and other special powers once allowed governors were removed to bring their status into line with that of the president, many of these powers being transferred to the central government. For this reason, it's safe to assume that the greater powers given governors during the earlier stages of the framing process can, in part, be accounted for by the concept of looser federalism existing at that time, although this was never explicitly stated in the Assembly. A combination of a tighter federal structure and a belief in the desirability of uniform executive procedures had worked to make the authority of the governors and the president nearly identical. Unquote, page 117. So long as the central government has the power to appoint and remove governors, governor cannot but look to the central government for guidance in the discharge of his duties. To cite one instance, the provision relating to the assumption by the central government of the executive and legislative functions of the state on the ground of the breakdown of the constitutional machinery in the state vests the entire power in the union. So long as this provision stands, the governor has necessarily to abide by the directives of the central government in its implementation. It's therefore necessary to indicate, at least in broad outlines, the principles which should guide the governor in the exercise of the discretion, if any, vested in him. Leaders of public opinion have pleaded for the drawing up of written conventions or instructions which should guide the governor in the exercise of his discretionary functions. The question whether instructions could be issued to the governor has been the subject matter of a lively discussion. The Vice President of India, inaugurating a symposium on the role and position of governors and center state relations, organized by the Indian Parliamentary Association, expressed himself against issuing any guidelines to governors for their identical conduct in similar situations. The then Union Law Minister, late Thiru P. Govinda Menon, who initiated the discussion on the role and position of governors, maintained that the governor had necessarily to exercise his discretion in relation to three matters, namely, appointment of chief minister, dismissal of the ministry, and reservation of bills for the consideration of the president. The first two items have already been dealt with earlier in this chapter, as in other matters. In reserving bills for the President's consideration, the Governor has to act on the advice of the Cabinet because Article 200 does not vest any discretion in the Governor. Thiru K. Hanumanthaya, Chairman, Administrative Reforms Commission disagreed with Pathak and stated that the President, as the appointing authority, could direct the Governor to follow the guidelines. Thiru K. Santhanam, in an article published in The Hindu dated the 6th May 1970, has dealt with the problem in an exhaustive manner. According to him, guidelines could be laid down not only for the governor but for the president as well. He has suggested the issue of a common set of guidelines for the president and the governor relating to the appointment of the head of the government, prime minister or chief minister, the right of the head of the government to ask for dissolution of the assembly, and the return of bills to the legislature for reconsideration. He has also suggested the issue of special guidelines applicable to governors only. Dr. K. Appadurai, writing in the Mail, dated the 20th July 1970, has made a similar suggestion regarding issue of instructions to governor. It would thus appear that the general trend of thinking is that some broad rules should be evolved to guide the governor in his actions both as an agent of the central government and as the constitutional head of the state executive. According to the Administrative Reforms Commission, amendment of the Constitution is not necessary for issuing guidelines to the governors. Thirusantanam, in his article mentioned above, has disagreed with the view of the then Union Law Minister that the Governor has discretionary powers in relation to the appointment of Chief Minister, dismissal of the ministry, and reservation of bills for the consideration of the President. Thirusantanam has stated that in those three matters, it is not right to say that the governor has discretionary power, as the governor is expected to act in accordance with the British conventions of parliamentary democracy. The position that emerges from the foregoing discussion is that the governor has to function in a dual capacity: one, as an appointee of the central government, and two, as the constitutional head of the state. Dr. K. Subbarao has expressed the view that the governor should not consider himself to be a mere agent of the center. This is the view expressed also by Thirupathak, Vice President of India. We had earlier in this chapter referred to his views on the matter. We are also of the same opinion. Dr. Subbarao has made some suggestions for insulating the governor from the influence of the union. One is the mode of appointment, and we have already referred to it. His other suggestion is that the governor should be rendered ineligible for a second term of office or any other office in the government, and he should not be removed from office on any ground other than proved misbehavior or incapacity after inquiry by the Supreme Court. We commend these suggestions for acceptance. The next point that arises for consideration relates to the functions in respect of which the governor has to exercise his discretion. We have stated earlier that the only areas in which the governor can be said to possess any power of discretion are three in number, namely: 1. Appointment of Chief Minister, 2. Dismissal of ministry, and 3. Dissolution of the legislature. We have already set out the practical limitations on the powers of the governor even in these fields. But with the present fluid political situation in several states, the role of the governor has assumed greater importance, and the various political parties have been accusing the governors of partisanship or subservience to the center. These criticisms may or may not be justified, but it should be ensured that the governor is placed above party politics, and that his actions are such that no suspicion of central interference should arise. The absence of any guidelines or conventions with reference to which the governor can exercise his discretionary powers makes his position difficult in moments of crisis. Conventions have to grow over a long period of time. We are extremely doubtful as to how far reliable conventions can be expected to be evolved. We have been working the Constitution for well over 2 decades, and it does not appear that suitable conventions have been formulated so far. It may be too much to expect that such conventions will grow hereafter. To give one instance, a resolution adopted by the Emergent Conference of presiding officers of legislative bodies in April 1968 requested the Government of India, among other things, to take urgent and suitable steps to evolve conventions in regard to the powers of the governors to dismiss ministries, and in that context, the conference stated that the question whether a chief minister has lost the confidence of the assembly should at all times be decided in the assembly. In the light of the recent happenings in some states, can it be said that this recommendation has been adhered to? We are of the opinion that suitable guidelines should be issued to the governors in writing. The constitutional validity of the issue of instructions to the governors has been doubted, while the study team has recommended the issue of instructions and has added that no amendment of the Constitution is necessary. Doubts have been raised on this point by others. Tiruke Santhanam shares the view of the Administrative Reforms Commission. The committee considers that if instruments of instructions are to be issued to governors, it should be given a constitutional footing, if only to avoid legal conundrums being raised at some future date. The Government of India Act 1935 provided for the issue of such instruments not only to the governor but to the Governor General also. Under that act, the instruments of instructions had to be laid in draft before the British Parliament and approved by it. It was only after such approval that the instruments had to be issued. Our Constitution, in the initial stages, contained a provision for the issue of similar instruments to governors. Subsequently, this provision was omitted from the Constitution. We recommend that a specific provision should be inserted in the Constitution, enabling the President to issue instruments of instructions to the governors, laying down guidelines or principles with reference to which the governor should act, including the occasions for the exercise of discretionary powers. As repeatedly pointed out by us in this chapter, the area of discretion of the governor is rather limited. The Constitution makes the Council of Ministers responsible to the Legislative Assembly. This necessarily implies that if at any time the question arises as to whether the ministry enjoys the confidence of the House or not, the only forum which could decide the issue is the Assembly and not any other authority. Recent events have raised several controversies, and accusations have been made against the central government of interference with this power vested in the state's assembly. The committee is not concerned with this aspect of the matter. The committee is drawing attention to this fact in order to indicate that the guidelines to be incorporated in the instruments of instructions should make it clear that, consistent with the constitutional provision bearing on this point, it is the Assembly and the Assembly alone which should decide the issue of confidence in the ministry. With this object in view, we recommend that the instruments of instructions to be issued to governors may specify in detail the manner in which the ministry should be formed. It may be provided as follows: A. The governor should appoint as chief minister the leader of the party commanding an absolute majority in the legislative assembly. B. Where the governor is not satisfied that any one party has an absolute majority in the assembly, he should, of his own motion, summon the assembly for electing a person to be the chief minister, and the person so elected should be appointed by the governor as the chief minister. C. The advice of the chief minister to the governor to dismiss any minister should be accepted by the governor. D. Where it appears to the governor not at any time that the chief minister has lost the confidence of the majority of the members of the assembly, the governor should immediately and of his own motion summon the assembly and direct the chief minister to secure a vote of confidence in the home. E. If the Chief Minister fails to seek the vote of confidence, or having sought it, fails to get the necessary vote, the Governor should dismiss the Chief Minister and the Council of Ministers headed by him. If the Constitution is to be amended, providing for the issue of instructions to the governors on the lines indicated above, the resultant position will be that the well accepted constitutional principle inherent in all parliamentary democracies, that the ministry holds office so long only as it enjoys the confidence of the legislature, would be incorporated in a constitutional instrument. It follows that in that contingency, the question of ministers holding office during the pleasure of the governor would not arise. The committee accordingly recommends that the provision in the Constitution that the ministers hold office during the pleasure of the governor should be omitted. It goes without saying that, except as provided in the instruments of instructions, the governor will have no power to dismiss the chief minister.